Good afternoon, everyone, and thanks for joining us for our latest webinar focusing on the built environment. For those of you who I haven't met before, I'm Peter Johnston, a partner in the disputes practice here in Mason Hayes and Curran. Today, the webinar is going to be focused solely on the area of residential landlord and tenant law. And certainly from my perspective, it's an area that seems to get perhaps more complicated rather than less complicated. And this is perhaps exemplified by the fact that over the last 16 months or so, I think we've had about 6 pieces of new legislation. And if you were watching prime time last night, it looks like there's going to be more changes afoot. So before I introduce our speakers today, I just want to put up a quick poll. It's an anonymous poll just to get a sense, I suppose, of your activity in the market at the moment. So Jeanette, we might put that up. So you can see we've put up 2 questions there. The first one being, have you served a termination notice in the last 6 months? And second, do you anticipate serving one in the next 6 months? So while we wait for those poll results to come through, I'm going to introduce our speakers here today. We're very fortunate to start off with, we have Jeanette Fogerty from the RTB, and Jeanette is Assistant Director and Head of Legal Enforcement and Legal Affairs in the RTB. Next, we have my colleague, Laura Farrell, who's a Senior Associate in our real estate practice. Laura literally wrote the book on residential landlord and tenant law, and her book in 2018 won the Law Book of the Year award, so that's quite an achievement for her. Laura is going to speak to us today about those new pieces of legislation that I just mentioned, and I suppose which ones you need to focus on. And finally, back by popular demand, we have my colleague, Colm Farrell. Colm's a Senior Associate in the disputes practice here in Mason Hayes, and he has a specialism in landlord and tenant law. We might just put up the poll results, Jeanette, if we have them. We get a sense of, so actually quite surprising, in fact, that there's not that much anticipation of termination notices in the next 6 months. So that's quite interesting. You're all probably well used to Zoom now at this stage, so you'll see the Q&A function on the bottom right-hand side of your screen. Please feel free to populate that with questions as we go. If everybody sticks to the allotted time, we should have some time at the end to put the questions that you have there to the speakers. And without further ado, thanks again for joining us today, and I'll pass you over to Jeanette.
Thanks, Peter, and thanks for inviting me here today. Like you mentioned, my name is Jeanette Fogerty, and I'm the Head of Legal Affairs and Enforcement in the Residential Tenancies Board. So the next slide there, what I'm going to talk about today is serving notices of termination and what we've seen with regards to notices of termination and the key message for serving notices of termination. So from the next slide there, we'll see that the Act is quite prescriptive on how you serve notices of termination. And rather than going into the prescriptive nature, for those interested in how prescriptive it is, Section 62 and Section 66 in particular sets out how to serve a notice of termination. It must be in writing. There is a notice period, and that's all linked to duration, which I'll talk further on. And there's specific criteria that must be included in the notice. It must have, for instance, the termination date. It must have that if the tenants wish to dispute the notice, that they've 28 days to dispute it with the RTB. So the key message here is that with the notices of termination, there is templates available on the RTB website where it is step by step of how to serve a notice for a particular reason, and the supporting documentation that you will need to provide for the notice of termination. So on the next slide, then we're going to look at how when you can serve the notice of termination. So the way the legislation works is if a tenant is there longer than 6 months, they're entitled to what is known as a Part 4 tenancy. So they have an entitlement to remain there for 6 years in total. And there's only certain grounds after the 6 months that a notice can be terminated. Before the 6 months, a notice of termination can be served without giving a reason. And again, this is dependent on that it's not a fixed term tenancy, or if it is a fixed term tenancy, that this, what we would term it as a probationary period, 6 months, is within that fixed term lease agreement for that ground to be utilised. After 6 months, I mentioned the reasons, and if it jumps into a further Part 4 tenancy, which simply means that the tenancy lasts for 6 years. So before the further Part 4 tenancy ends, a landlord can currently serve a notice of termination to end the further Part 4, and they must give a reason but it does not have to be a ground. So they can give any reason in accordance with the law, but it does not have to be within the grounds. But again, I'll talk through further on in respect to this in the next slides. Jeanette, please. Okay, the first one of the reasons that a landlord can terminate a tenancy, whether it's a fixed term tenancy or it's not a fixed term tenancy, is if they breach their obligation. So a landlord, if there's a breach of obligation for certain elements, a landlord can serve a warning letter to a tenant for the breach of obligation, asking them to mend their hand with regard to the breach. Now, the breach of obligation can also include that there's rent arrears and there's a breach of obligation. So this warning rent arrears or warning breach of obligation notice is served first, and Laura will talk more on the rent arrears piece. And then thereafter, if the obligation is not remedied, the landlord can continue to serve a 28-day notice of termination on the tenancy. So you don't have to link that to the duration of the tenancy. If there is serious antisocial behavior, then a 7-day notice can be served. But it is important to remember there's a very high burden of proof required for the service of a 7-day notice. So it would be threat to the life of person or threat to the fabric of the dwelling for a 7-day notice. So for the next slides, then we will look at the particular reasons. So I mentioned that after 6 months, there's particular reasons. There's it's now 7 grounds that we can look at. So breach of obligations, and breach of obligations is kind of for rent arrears is the first one, first 1 and 1A that is brought in. Then if the property is no longer suited for the tenant's needs, for example, overcrowding, a landlord can serve a notice. If there isn't sufficient bed spaces within the dwelling, a landlord can serve a notice. And with that, a written statement is required on this. If the property is being put up for sale is another ground, and this requires a statutory declaration. And there's also a new High Court law around requiring this 9-month period, that it's on the date of service you must show your intention for the property to be sold. So you can't just sit on your hands and say, I'm going to sell my property, and when the tenant gets out, I will show that I'm going to sell it. You must, at the date of service of the notice, show your intention to sell. So that's like talking to agents and doing the paperwork. So that has been clarified in law in respect of that element. If the landlord requires the property for their own or family use, and again, this is a statutory declaration that's required, and with a lot of these, there is this offer back. So you must offer the tenancy back to the tenant if the tenant provides their updated contact details within a certain period of time. The next piece is substantial refurbishments. If you're carrying out a substantial refurbishment, and this has been clarified in law again about substantial refurbishments, it requires a written statement. It requires proofs to show that this refurbishment requires the tenants must vacate for a period of time. And the final one is the change of use of the property. So for instance, if it was going from residential to commercial, and again, it's a written statement. But this might seem quite complex, but like I said, we have step-by-step guide to terminating a tenancy for landlords. And it has been shown when people use those templates, they have been effective and valid notices are served. So for the next slide then, this is just a kind of a sample of the warning, the sample warning notices that we have up on our website, and the self-declarations. So it's kind of step-by-step guide in respect of that. If we can move on to the next slide, which I think, yeah, that's the final slide. Again, just to reiterate and recap that the important piece to learn is that there's templates available to serve. And most of the time, before we had these templates up there, we were seeing nearly 70% of notices were termed invalid and 30% were deemed valid. We put up these and it's now down at 40%, but still we would like it to be lower than that, because obviously if a notice is deemed invalid, a landlord has to reserve the notice again. And just to note as well, I was talking specifically on landlords. With tenants, they must also serve a notice of termination if they're ending the tenancy, but the reasons piece is not required in respect of their ending the tenancy. So thanks very much. I'm going to hand it over to Laura to discuss the various pieces and changes to the legislation.
Thanks very much, Jeanette. That was interesting and a particularly interesting statistic about the way notices of termination whole-scale increase in validity given the standard notices on the website. So if I can move through to my first slide. Since March of last year, there have been 6 new Residential Tenancies Acts, a feast of legislation. They're listed there on the slide. Now, some of these are acts purely intended to alleviate the consequences of the pandemic. They're emergency legislation. Others are acts of general application, and there's one act that is a mixed bag with both emergency rules and rules that are intended to be of general application. And in this context, I think any of us could be forgiven for thinking we haven't now got a clue what is going on. And I wanted to spend these few minutes today giving a high-level review of each of those pieces of legislation. And we will go through and we will see what is in, and perhaps just as importantly, what is out. And if anybody had any specific particular questions at the end, I'd be happy to try and answer those in the Q&A. So the story begins on the next slide with the Emergency Measures in the Public Interest COVID Act 2020. This was really the high watermark of protection for tenants. It was the piece of legislation of blanket bans, no tenancy terminations, no rent increases. And this piece of legislation ceased to apply on the 1st of August 2020. And in what follows, we never get back again to this position of great protection for tenants. It's the high watermark. The next act on the next slide is the Residential Tenancies and Valuation Act 2020. And this is the one that is the mixed bag of emergency legislation and also rules that are of indefinite application. This was the act that introduced the construct of the relevant person. So with a broad brush, a relevant person is somebody who is experiencing financial hardship because of the pandemic and is in receipt of public monies to alleviate that hardship. And now it is only the relevant person who will benefit from this act's COVID protections. So this act affects tenancy terminations, but it only affects the termination of a tenancy of a relevant person, and then only affects the termination of the relevant person's tenancy for rent arrears. Now, the Act does not say that landlords cannot terminate the tenancy of a relevant person for rent arrears, but it just alters the notice period that needs to be given. So it's generally a 28-day notice period, and this Act says for a relevant person, it is a 90-day notice period. And this Act said that that 90-day period couldn't expire before the 11th of January 2021. The Act also provided that for relevant persons, there could be no rent increases taking effect before the 11th of January 2021. Turning now to what this Act said to the general law, this Act made general changes to terminating tenancies for rent arrears. So the rules before this Act were where a landlord wanted to terminate a tenancy for rent arrears, he would serve a warning letter, which had to be for a minimum of 14 days on the tenant, and then would proceed to serve the notice of termination on the tenant. But by virtue of this piece of legislation, it's now a minimum 28-day warning letter that the landlord needs to serve. And if he goes on to serve the notice of termination, he must serve that notice of termination on the RTB on the same day as he serves it on the tenant. If we can move on to the next slide, we get to our third piece of legislation. We're at 3 of 6 now. So this is emergency legislation again. It is the Residential Tenancies Act 2020. And this act is going to come in and out of application as and when the Minister for Health imposes a 5-kilometre travel restriction. So the Act proceeds upon the basis of an emergency period, and the emergency period relates directly to those periods of time in which there is a 5-kilometre travel ban. Now, during an emergency period, notices of termination can be served, but they cannot take effect. So say, for example, a landlord served a 28-day notice of termination during a particular emergency period. What the Act says is that before the notice period would run, we have to wait for the end of the emergency period. From the next day, we would then give a 10-day grace period, and from the expiry of that grace period, the 28 days notice of termination would run. Now, this Act isn't quite as protective of tenants as was the very first piece of legislation that we looked at, because there are now exceptions where even during an emergency period, the notice of termination can run and can expire. So examples of those exceptions are where a tenancy is being terminated because of antisocial behaviour, or where a tenancy is being terminated for behaviour that threatens the dwelling. The next and the fourth of those 6 pieces of legislation, on the next slide please, was the Planning and Development and Residential Tenancies Act 2020. So if you recall the relevant person who was introduced by the second piece of legislation we looked at, what this Act did was to extend in time the period during which those protections to a relevant person were going to apply. And actually that was extended out again by another Act. So now we're in a position where protections for relevant persons will extend up until the 12th of January next year, the 12th of January 2022. But the Act didn't only extend the protection in time, rather in a further rebalancing of landlord and tenant rights, the actual protections that were given to relevant persons are now pulled back from. So now for a relevant person to take advantage of those protections, they have to first themselves take certain steps. They need to formally ask the RTB to assist them in getting MABS advice, and the relevant person needs to formally ask the landlord for a date when they can have a meeting to discuss the rent arrears and formulate a plan for the repayment of those arrears. And there are now even circumstances where a relevant person won't be able to benefit from the COVID protections. There are a few such circumstances, but an example of one circumstance is where the landlord can show that to give those emergency COVID protections would cause the landlord undue financial hardship. So that brings us up to the 5th Act on the next slide, please, which is again more emergency legislation. And that's the Residential Tenancies Act 2021. So this Act amends the piece of legislation we looked at that's going to come in and out of operation depending upon when the 5-kilometre travel ban is in place. And because of this Act, even during an emergency period, a notice of termination for rent arrears can be served. So now the only protection for rent arrears that will accrue is that given to a relevant person in the circumstances that we have already looked at. And if we could move on, please, to the sixth and final act. So this is Act of General Application, and it is the Residential Tenancies No. 2 Act 2021. What this act did was to make changes to rent pressure zone legislation and also make changes to rent review rules. And Colm is going to talk about those in a moment. But it made other changes, and we know our clients who provide student accommodation have been very interested in these changes. So this act limited the amount of rent that could be paid, that a landlord could be required to be paid in advance, or the amount of deposit that a landlord could be required to be paid by a person in order to secure a tenancy. But the act carved out an exception to this. So it is possible for more rent to be paid in advance if a student is willing is the word the legislation uses, to pay more, and if there is the agreement with the accommodation provider to pay more in advance. Another thing this act did was set out a rule that now students don't have to give more than 28 days notice to terminate their rental agreement. So in summary, in terms of key takeaways, it is that unless and until a 5-kilometre travel restriction is imposed, the only COVID protections are those that apply to relevant persons that we have discussed. So thank you very much for listening to me. I hope that high-level review was useful, and I'm going to pass to Colm now, who's going to talk about rent reviews.
Thanks for that, Laura, and some really interesting information there, and particularly around students, I suppose, given what's been in the news the last couple of days, just around students and food banks down in Cork and difficulties that students are having with accommodation generally, so quite topical, I think. So as Laura discussed, I'm going to discuss rent reviews today. I suppose, as a lot of you will be aware from the media, and particularly those of you who in the audience are renters, rent continues to increase, and what we've seen in the media and the reports is that this is very much the case more so outside of Dublin than in Dublin, where outside of Dublin, rent increases are running at about 10.4% of inflation. And this is the highest rent increase we've seen since 2019. And I suppose when you're looking at the reasons for this, a lot of it is, in part, is due to COVID, where people are leaving the capital and have been moving out. But what we are seeing is that, and speaking to clients, is that people are coming back to Dublin as well. So it may be that this balances out over time. So in addition to rent increases, what we're just seeing is that the cost of living generally is increasing, and we're all aware of this, I suppose, even just from the utility bills and whatnot over the last couple of weeks. And again, the notifications we're getting from our utility providers that things are going to increase for the winter. And again, this was something that's been very topical this week in relation to the budget. But as you'll probably have seen, the likes of Sinn Féin, for example, were very disgruntled with the budget because there's nothing really there for tenants. And when this was put to Leo Varadkar, he was saying that the supply of additional properties into the market is going to be the relief the tenants are going to get. So I was very happy with that when I was doing my dry run of this last night at home, trying to learn my speech until I put on prime time and see that the Minister for Housing is now saying that there's going to be new introductions or new rules or new limits introduced in this particular area in the next couple of weeks. So what I'm saying today is relevant and correct as of today's date, but it may be that we need to revisit this in a couple of weeks. So Sinead, we might just go on to the next slide there, if you wouldn't mind, please. And the audience will see that that's a poll. And the question is, the cost of rent in Ireland as a percentage of a person's monthly outgoings is 3rd, 6th, 10th, or highest 12th in the world. And I'll just give you a second to answer that while I take a sip of water before I launch into this 10-minute talk. So Sinead, if the answers have come in there, you might just put up the response or the reply, if you wouldn't mind. So that's interesting. So a lot of people have said it's the 3rd, and the people who have said it's the 6th would actually be correct. And this is a survey that was carried out during the summer by money.co.uk. So it puts us behind Hong Kong, Singapore, Qatar, the UAE, and Kuwait, making us the 6th most expensive country in the world, with Irish tenants spending about 37.2% of their outgoings on rent on a monthly basis. Interestingly, rents are highest in Still Oregon and rents are lowest around the country in parts of Donegal, just as an aside. So I suppose with this in mind and the fact that it's just very topical, I thought it'd be appropriate today to look at rent reviews wholesale. What are they? How do I do them? And how do I avoid all these common pitfalls and getting it wrong? So rather than necessarily just focus on the revised legislation, I wanted to go back to basics and take it from the top and go through it step by step, and then take any questions at the end. So Sinead, we might just move on to the next slide, please. So in terms of going back to basics, the first thing we need to understand is that not everyone is treated equally, I suppose, and I say that in that parts of Ireland are designated as rent pressure zones, whereas others aren't. And the way in which rent reviews are carried out in the RPZs and non-RPZs is different. However, the guiding principle, regardless of where the dwelling is situated, is market rent. And that's the first point there in the slide. So market rent is defined in the legislation as the rent that a willing tenant not already in occupation is prepared to pay, and a willing landlord is willing to accept in respect of the vacant property. So that's the statutory definition. I suppose breaking that down in the nuts and bolts, what does it actually mean? So what you're looking at is comparable properties in terms of size, type, character, and area. And if we take each one of those individually, I suppose the first one there, size, should be quite straightforward. A 3-bed semi-house or semi-property, for example, is not going to be the same as a bed set when it comes to trying to look for comparables. I think that effectively speaks for itself. If we move on to the second piece there, which is comparable type, there's a lot of tribunal decisions around this when it comes to rent reviews and what is a comparable property and not a comparable property under this heading of type. So one of the RTB decisions says that the best comparator in terms of types of property, for example, for an apartment in a complex, is another apartment in that complex. But you can run into some difficulties here because the legislation provides that the comparator must have been advertised within the last 4 weeks. So you can envisage a situation where I am the landlord and I want to do a rent review in respect to my property, but there's no other vacant advertised property in my block or in my development, which is similar that I can rely on as a comparator. And that means you have to go a bit further afield. And that's where it's really important to make sure that the type of property that you're looking to as a comparator is a true comparator. In terms, another thing that the RTB has considered in relation to this type heading is whether or not the condition of the property will be taken into consideration. So again, by way of example, you have 2 properties side by side, both are rented. Landlord A keeps his property in an extremely good condition. Landlord B maybe less so. But that condition piece, because one is better than the other, doesn't necessarily mean that it's not a comparable for this type heading when it comes to rent reviews. So that's just something to bear in mind. In terms of the character, what I suppose you see from reading the RTB tribunal decisions, is that typically speaking, character there is new builds are probably more comparable to new builds and old builds comparable to old builds, excuse me. Or you could envisage a situation, for example, you would have an old build which has been modernized or renovated, which may then be comparable to a newer build as well. And in terms of area, again, this is quite interesting to read the RTB decisions in terms of what is considered to be a comparable area. I'm looking out at Grand Canal Dock here and I can see extremely expensive penthouse apartments, and clearly they're not going to be comparable in terms of area to, for example, a house down in Longford or Cavan or down in Cork even. But what is very clear from the decisions is that it needn't necessarily be in the same postcode. So for example, an apartment in Dundrum, all other things being equal, will likely be comparable to an apartment down the road from Dundrum and Goatstown, for example. And as I mentioned a moment ago, one of the things you have to remember is that the comparables have to have been advertised within the last 4 weeks. And as I said, this can cause a practical difficulty. And one of the things that you often see tenants complaining about is also that this can cause almost an artificial comparison, because you may find for larger landlords, for example, not only do they own the apartment that they're trying to do the rent review on, but that they own the entire block. So effectively they're controlling the rent in that block and they're controlling what the comparators are going to be. So having considered, I suppose, just the market rent generally and the fact that we can't get away from it, whether or not you're in an RPZ or not in an RPZ, the next thing to consider is what is the story with the RPZs and where is your property? And this is something that you'll need to check every time you do a rent review. So the RPZs were introduced in 2016 on a very limited basis, and for the most part they covered Dublin, a number of sort of Dublin suburbs and parts of Cork as well. And the rationale in introducing the RPZs was to give a certainty and a transparency to areas in which rent was going up at a higher rate than elsewhere in the country. I suppose if you look at the figures and the statistics that have been published most recently, you have to question whether or not this RPZ mentality or rationale has actually been met at all. So as matters stand, there's 54 separate RPZs, and simply because a property is not in an RPZ when the lease is granted originally, it may well be in an RPZ by the time you come to do a rent review, and a list of the RPZs is on the RTB website. So it's a really important point of reference, just to make sure you're applying the right rules when you're doing it. And then just in terms of the legislative amendment, which is, I suppose, the smaller piece in the overall rent review scheme, what does it mean? So for those of us who do rent reviews and work in this area, we're all familiar, and we've been speaking about it for years at this stage, about the 4% cap and what does that actually look like. And more recently, then you saw landlords trying to circumvent the 4% cap where they hadn't done a rent review by reason of COVID, and were trying to do 2 rent reviews back to back and see if they could get an 8% uplift, for example, over 2 years. What has been introduced now in an attempt, I suppose, to again steady the rents is this harmonized index of consumer price. And that's something I have to read no matter how many times I've read it. I can't seem to maintain that particular phrase in my mind. And the rent index, again, is on the RTB website. So like previously, where you put in your figures in terms of when was the rent last set and what was the last rent, and it would then spit out the 4% increase. You now put in those variables and it will provide under the harmonized index of consumer price what the increased rent is allowed to be. It is interesting as well that the RTB website has maintained the old calculator for the 4% in addition to the harmonized index of consumer price calculator. So you can actually see the difference just as a matter of interest more than anything else. And I suppose the other thing to remember when you're doing these rent reviews under the new rules is that the index can change on a daily basis. So if you do your calculations on a Monday, for example, you should be sending out your notice to the tenant on a Monday as well. Don't let it sit there, because what you could find is that by the time you actually send it out, that the index may have changed. And when it comes to a dispute, for example, that you won't be able to stand over the figures that you've inserted in your rent review notice. So you might just move on to the next slide there, Jeanette, please. So I suppose now that we understand what it is and what it's all about, the question is, how do I do it properly, and how do I make sure that I'm in the right side of the notices and still not within the 40% of notices that Jeanette was saying are found to be invalid? So the first thing is how much notice is to be given. So a landlord has to give a minimum of 90 days notice before carrying out a rent review. And as we'll all be aware, the RTB legislation has various timeframes in terms of notice periods. And I always err on the side of caution, and this is something that I can't impress enough on clients or individuals who are doing this themselves. Just because it says a minimum of 90 days, err on the side of caution. It's going to have to go out by post. Counting won't start until the day after you send it. And if you're trying to skimp on time at the start, you can be guaranteed that you're going to lose on time when it comes to dispute at the end of the day. So give additional time is what I would say. And then just in terms of what does it actually look like? So there's prescribed and very prescriptive forms that appear on the RTB website. And if you follow those, in theory, you should be able to get this right. But what I would say is that even with the best will in the world and following the forums, I do think you need to have a good general understanding of what the rules are to make sure that you don't fall foul of it. So the forms are, I find, in my view, are worth reading from time to time, particularly if this is a legislative amendment. And if you are working from forms that you've saved on your system as a precedent, rather than necessarily working from the forms as they appear on the RTB website from day to day. So just make sure you're working from the right ones. And there is, I suppose, a belief, and it's mistaken amongst some landlords, that simply because a tenancy comes to an end, the landlord can set the rent at whatever level they want. And that's definitely not the case. The future rent is going to be determined by the previous rent, and unless you can rely on the exemptions, which I'm going to come to in a minute, you're effectively stuck with that. And you do see disgruntled landlords who have given a sweetheart deal to, for example, a friend or the son of a friend or something, and they've given them rent for 500, 600, 700 euro for a long time, and they've been in there while they were in college, for example. That person moves out, and the landlord then wants to increase the rent. The landlord will find himself caught by that sweetheart deal that he'd given previously, and unless he can rely on the exemptions. Because if the properties are within the RPZ, you have to apply the calculator, and you can't simply just decide what you think the rent should be and avoid what you've done previously. In addition, the landlord is obliged to give, and a tenant is entitled to a lot of information when it comes to rent reviews. So a new tenant is entitled to know what the previous rent was, when it was set, and how it was set. So it can't be a case that you're going to hoodwink a new tenant about what their rent is going to be. And in terms of how often you can do it, so the rule is that in an RPZ, you can do a rent review within every 12 months. And outside RPZs, it's every 24 months. And under the more recent legislation, the RPZ has been extended to December 2024. So this is with us for another couple of years, at least at this point. And I would say as well that there's a positive obligation on a landlord to notify the RTB that they've carried out a rent review. And again, there's a form on the RTB website in relation to that, and make sure you do it. And just moving on to the next slide then as well, please. So once you've managed to get your head around the rules, of course, there's always going to be exemptions and exceptions about how those rules apply. So there are a limited number of exemptions in which a landlord can effectively avoid or evade the RPZ cap under the new index. And those are set out here on the slide here in front of you. The first is that the property hasn't been let for the 2 previous years before the start of the new lease. So we have seen as well, and again, this has been documented in the papers and got a lot of attention, where certain landlords were leaving properties fallow effectively for 2 years. So rather than get someone in on a lower rent, which would then stymie the landlords when they want to do a rent review in the future, they were looking at keeping properties effectively empty for 2 years so that they could then set the rent as they wish to do so. And again, I suppose this is feeding into the vacant property tax that has been discussed time and again, and that we're all quite familiar with. The next exemption then is the protected structure. So if the dwelling is located in a protected structure, or the protected structure hasn't been previously rented, or it's an anticipated protected structure, then the exemptions apply and the landlord can effectively circumvent the rules. And the third is the substantial change. And this was something that gave rise to a lot of dispute and a lot of talk and I suppose disputes before the RTB. When this concept was introduced originally, there was a confusion between substantial change and substantial refurbishment. So substantial refurbishment allows a landlord to terminate a Part 4 tenancy, whereas substantial change allows a landlord to circumvent the RPZ rent caps. And there was a bit of confusion between the two of those and what actually constituted substantial change, and whether, for example, licking the walls with paint and putting in a new countertop was going to get you there. And as time went on, there was very helpful guidance from the RTB in relation to this. And more recently, what we now have is that it's actually prescribed for in the legislation. And it actually can be quite difficult to fall under the exemptions. So the substantial change has a number of different headings. The first is that the landlord has increased the property size by 25% or more, or that they've increased the energy rating of the building or the dwelling by 7 BER steps or more, or a cumulative of 3 of the following: that the internal layout of the dwelling has been changed permanently, or that the dwelling has been adapted for disability, or that there's a permanent increase in the number of rooms, or that, again, that there's been certain BER improvements. So it's important to note there as well that just because a landlord is doing what's required in terms of maintaining a property or bringing it up to scratch, that won't count as substantial change. That's a minimum that the landlord is supposed to be doing in any event. So if we actually consider how the substantial change piece or any of these exemptions apply, if you take, for example, a typical apartment in a development, chances are that the landlord won't have space to do 25% extension. So you're knocked out under that one when it comes to substantial change. If it's a relatively recent build, chances are it should be quite energy efficient. So you may not be able to get the 7 steps improved in BER search. So then you're into this sort of these other cumulative tests and whether or not you can actually do them in terms of adding additional rooms or changing the layout. And the question then becomes whether on a commercial basis, it's actually worth the landlords expending all of this money to try and circumvent the rules to get the uplifted rent. So again, that's a bit of a maths equation that has to be done to see if all the figures stack up. And like with the rent review, there is a prescriptive form that a landlord is required to submit to the RTB if they are relying on the exemptions. And again, if you follow that form, you should get it right. But as I said, you do need to have a general understanding of what the position is. So just moving on to the next slide, and I'm conscious of time, so I'm going to skip over a case study. And we can take some questions at the end in relation to that, which is just that the landlord there, in very quick summation, but I won't go into it, in a very quick summation, the landlord, and this was before virtual hearings, hadn't appeared at the tribunal, put in a position paper, wasn't in a position to actually give evidence and rebut some of the positions that the tenant was put forward. And effectively the tenant was successful in his argument that his 1-bed kitchen diner sort of apartment was not comparable to the 2 and 3 beds that the landlord is looking to rely on in respect of his rent review. So moving on to the last slide there, Jeanette. So we've discussed what rent reviews are, we've discussed how to do them, and I suppose the last piece that I wanted to touch upon is what are the ramifications if the landlord gets it wrong. So in the usual way, if a tenant believes that the rent review has been carried out incorrectly in terms of insufficient notice or that it's excessive, then the tenant can bring a dispute to the RTB in the usual way. And while that dispute is ongoing, the tenant should continue to pay the previous passing rent for the duration. And the RTB can either affirm that the notice of rent review is valid or invalid, and can actually give an indication as to what the rent should be. As is always the case, there is fines and imprisonment possible where you knowingly mislead the RTB. So if a landlord knowingly misleads the RTB in a rent review, they're subject to a fine of €4,000 and or up to 6 months imprisonment. I suppose something that I want to touch upon and probably warrants a standalone session on its own is just the investigation and sanctions procedure that was introduced about 2 years ago at this stage, which allows the RTB to investigate what's considered to be improper conduct. And where a landlord fails to comply with the RPZ rules or the rent setting rules, that's considered improper conduct, which can be the subject of an investigation. And it's worth, I suppose, the RTB kind of word damage is €15,000 and costs of €15,000 where you're found to have carried out improper conduct. And the RTB are saying that there is going to be a campaign to make sure that landlords are doing what's required, and particularly in light of these increased rents that we're seeing in the market. But that necessarily isn't being borne out by what we've seen in the statistics so far. So as I understand it from Janette and the statistics from the RTB, the greatest fine to date has been €3,000, and the RTB is very much in favour of engaging with landlords around this to bring about compliance. That's not about penalising landlords, but making sure rather the tenants aren't being taken short. So that's it at a very high level, and hopefully has given a flavour of rent reviews from start to finish. I'm going to pass it back to Peter. I think we're going to open the floor to some Q&A, and I can see there's questions in already. Many thanks.
Great. Thanks, everyone. And thanks in particular to Jeanette for giving up her time. I'm conscious of our 45-minute